District Court Judge Annalisa Torres issued a decision allowing the records authored by former SEC Corporation Finance Division Director William Heinemann to be made public, giving Ripple Labs a victory in its ongoing legal dispute with the Securities and Exchange Commission. The majority of the materials concern a lecture Heinemann gave in June 2018 at the Yahoo Finance All Markets Summit. According to Heinemann, is not a security, although it's too soon to say whether the terminology used in the speech will be as meaningful as the SEC allegations that sales of Ripple's XRP tickers down 0.48 violated U.S. securities laws. Ripple Labs considers the speech to be a key piece of evidence in the lawsuit the SEC has launched against it. Firm recommend. There is a great deal of ambiguity regarding the speech's context and Heinemann's actions prior to it. Judge Sarah Netburn of the District Court decided that the emails and speech drafts were not shielded by the deliberative process privilege, as the SEC had argued, and Judge Torres' judgment overturned the SEC objections to the materials release. The materials were subsequently subject to the SEC assertion of attorney-client privilege, which was rejected by Netburn in July. The SEC challenges to Judge Torres' judgment were dismissed. On December 2020, the SEC filed a lawsuit against Ripple Labs and its former CEO Chris Larson, as well as its current CEO Brad Garlinghouse, alleging that the company's cryptocurrency XRP tickers down 0.48, xrp tickers down 0.48 is security because it was used to raise money in 2013. The case is a somewhat uncommon illustration of an SEC lawsuit that proceeds to trial, perhaps setting a precedent rather than having a settlement as the resolution. Ripple has pursued a number of defensive tactics after the business initially believed the case was going against it. Ripple Labs and the SEC submitted applications to the U.S. District Court for the Southern District of New York for a summary judgment. The SEC, who is suing in the Ripple case, submitted a motion to seal the contentious Heinemann speech materials. The regulator made the case that redaction takes precedence over the public's right to see records that are not relevant to the. On May 16, the request was rejected by the judge, delivering a victory for Ripple. A number of technical indicators reinforced the bullish view, and XRP responded with a 5% upsurge. As a result of Judge Annalisa Torres' decision to reject the SEC request to have the Heinemann documents sealed, Ripple has gained a new victory in its XRP litigation against the U.S. Securities and Exchange Commission. To be clear, speeches by Heinemann documents. William Heinemann, a former director of the SEC Corporation's Finance Division, reportedly claimed that Ethereum is not a currency in his lecture at the Yahoo Finance All Markets Summit. The chief legal officer for payment network Ripple blasts the U.S. Securities and Exchange Commission's defense of the suit's use of the Heinemann speech documents as evidence. The U.S. SEC submitted a motion to the court requesting that the controversial Heinemann speech materials be sealed. The regulators claim that its mission outweighed the public's right to access documents that have no relevance to the court's summary judgment decision. Among other things, served as the foundation for the case. District Court Judge Annalisa Torres has made a different decision based on the most recent court order, stating that the documents are judicial documents subject to a strong presumption of public access. In the ongoing legal battle against the SEC, the ruling is a resounding victory for Ripple and the whole XRP community. SEC Judge Torres stated that the Heinemann speech documents would reasonably tend to influence the court's decision on a motion, as shown in the clip. Notably, this wasn't the SEC's sole application that was turned down. The court rejected the regulator's arguments that sealing the deliberative process privilege does not shield the Heinemann speech documents since they do not relate to an agency viewpoint, decision, or policy, according to Judge Torres, who supported this ruling. Nevertheless, some of the SEC requests were granted, including as the one in which the organization requested that the names and identities of the XRP investor declarants and the regulator's pundits be obscured. The organization also desired the individual and false information about the defendant's finances. Similar to this, parts of Ripple's motions were muted. Among them are mentions linking its earnings to XRP sales and the amount of compensation provided to trading platforms, among other things. After winning, Ripple's price turns bullish. The court's admission of the Hyndman speech into evidence tilts the balance in favor of the defendant because it was a key piece of evidence in the continuing legal battle between Ripple and the SEC over allegations of securities law violations. As a result, the price of Ripple increased on this news, with a daily increase of 5.35% and a 40% rise in 24-hour trading volume, both of which indicate a return of investor vigor. The remittance token overcame significant obstacles and climbed a rebound rally above the resistance levels. Uncertain crypto policies in the United States have prompted companies like Ripple to consider investing elsewhere. How do you believe this will impact cryptocurrency and the U.S. economy? According to Brad Garlinghouse's claim that Ripple recommended the U.S. to follow the U.K. based on recently made public court documents in the Ripple lawsuit, in light of these allegations, Ripple is claimed to have paid 6 exchanges between $1 million and $5 million. David Schwartz, the chief technology officer of Ripple, has responded to shed some insight on the matter in response to a conversation that was started by the fictitious, self-proclaimed detective. Schwartz provided more details. How long will cryptocurrency investors continue to believe in Ripple after the SEC extract? Although Ripple's lawsuit against the SEC is anticipated to be resolved soon, the company has been badly impacted by the prolonged delays. The effects of investors' waning confidence may be visible on the chain and in Twitter rumors. How much will an excerpt cost in mid-2020? Early today, rumors began to circulate on Twitter that Ripple and the regulatory body were scheduled to meet in secret on a daily basis. The initial source of these claims was a tweet from a pro-XRP, but soon after, attorney John Deaton shot down these rumors as potentially false. In addition, he said that attorneys for the SEC and Ripple might meet whenever they have a meeting. As the summary judgment keeps getting delayed, we still don't know if there's any truth to the situation or not. However, as the summary judgment keeps getting delayed, we still don't know if there's any truth to the situation or not. As a result, we still don't know if the regulatory body received the summary decision or not. However, social media users have started to speculate that the regulatory body received the summary decision by May, and realizing they were losing, decided to settle outside of court after learning a decision from Judge Torres was expected in July. We've been here for roughly 5 weeks, according to John Deaton, and she gave the Dobert judgment. Given the current regulatory climate in the United States and the industry's efforts to adapt to it, a new Supreme Court consideration may have a significant impact on the fortunes of Ripple and Xrp, both of which are currently struggling. The summary judgment could come out at any time now, signaling that supporters and investors are now waiting for the verdict this month on May 6. We will have reached the 60-day threshold at which point a decision may be made. That gives agencies rulemaking authority is being re-examined by the Supreme Court. The lawsuit that could invalidate a rule that allows organizations like the SEC to define their own powers will be heard by the U.S. Supreme Court starting in October 2023. The aim is to provide updated standards for how these institutions, like financial regulators, should function. Therefore, if the new Supreme Court appeal limits the SEC's ability to define which cryptocurrencies are legal tender, it will have a negative impact on the SEC. XRP tokens, according to Ripple Labs, were marketed as unregistered securities by Ripple and its representatives. By market value, Ripple is the third largest cryptocurrency. According to Ripple's defense, the XRP is not a security but rather a cryptocurrency similar to Bitcoin and Ethereum. In its most recent quarterly report, Ripple stated that the SEC had not been able to persuade a judge to order the company to turn over confidential material. According to reports, the files at issue concern Ripple's legal opinion on whether or not to disclose the information. According to Ripple, the records would show that it didn't intentionally violate any securities laws. We stop here for now. Thank you, and see you in the next one.